Hello and welcome to the Arbitration Conversation. So in this arbitration conversation, it's going to be in honor of the Olympics. The Olympics are going on right now in Tokyo, and we are thinking about how arbitration intersects with the Olympics. And it does in many ways. And for that, we have a true expert in the field. We have Richard Faulkner. Now, Richard Faulkner, not only is he an expert in ADR, mediation, and arbitration, he's been an arbitrator with the AAA for a very long time. He began in 1979 and then started arbitrating in 1981. So he has done his fair share. If you keep count, I'm sure it's quite a few. And but not only that, like you've been a real leader in education around arbitration as well, and have been involved in some very, very high profile arbitrations at that and involved in amicus briefs in very important arbitration cases, including Rent-A-Center. So Richard, first of all, thank you so much for taking time with us.
Oh, delighted to. I love teaching and I love to see other people are interested in arbitration. One of the things I've tried to do over the decades has been to bring other people into arbitration because it's important that we have a newer generation of people coming in. And especially, a lot of you ladies, when I started in the 70s, female arbitrators were effectively unknown. And then as I became more active in the international arena, I found more and more, women in international arbitration, not so many in sports arbitration issues yet. And then I know I work with CPR, and I'm on their panel of distinguished neutrals, not the AAA panel. They took exception to some things I had to say about them on Capitol Hill. And so I'm a semi-retired judge, and so I tend not to bite my tongue. And, I note that CPR has done huge outreach for obtaining diversity on its panels, the same with the ICC and the London Court of International Arbitration. And this is important because we need more people interested in ADR and more people with diverse backgrounds.
100%. Well, 100%. I mean, one of the main impetus and reasons for our kind of reviving arbitrate.com was precisely that reason. We want more voices, fresh voices, diverse viewpoints. So well said, absolutely. And as we think about the Olympics, right, and we think about the international arena, you were involved in all four arbitrations involving Lance Armstrong.
Oh, yes.
So maybe you want to share with us a little bit about that, because we were chatting before we started, and in fact, people think of just the maybe one arbitration and the doping questions, but in fact, it goes much deeper than this. So
Yes.
If you could share with us a bit about the progeny and what happened in these four arbitrations that you were part of.
Sure. The first of the arbitrations was an ad hoc, non-administered arbitration solely creating the arbitral tribunal in the parties' agreement with a very unusual provision for continuing jurisdiction. They specifically negated the entire concept of a tribunal becoming functus officio. And it was not apparent as to why they chose to do that in the agreements, but they did. And so in the first case, we obviously were presented with Mr. Armstrong's claims that SCA had not properly and timely paid him for winning the sixth Tour de France, and they defended on a basis of that he had ostensibly been doping. Well, it was a very contentious set of hearings, super good lawyers on both sides. Jeff Tillotson did a magnificent job for SCA, and Russ Herman and Lisa Blue were great on the Armstrong side, and the panel eventually reached a decision finding that, in fact, the money was due, and that is what our first award ordered. Well, then there were some problems that resulted in a second demand for arbitration by Mr. Armstrong. and that matter was expeditiously set. I've never believed in allowing cases to hang around. They're not fine wine. They're more like old mackerel. They do not improve with age. And so as the case approached a hearing date, it got resolved. Other problems arose. Mr. Armstrong filed a third demand for arbitration. And those issues, as a hearing date approached, were also resolved. Then time went by, but remember, there was no provision for the panel to terminate its activities.
That's so odd. That's very odd.
I thought
Yeah.
so too, but apparently they had concerns over the actual enforcement and collection of the award, which was a substantial amount of money. I mean, we're talking $10 million. And so then SCA learned through a variety of sources, including apparently one of the other sports arbitration problem areas, which was the doping scandals in baseball. And the same Department of Agriculture investigator involved in the Barry Bonds case and others somehow became involved in looking at Lance Armstrong. Very peculiar why a Department of Agriculture investigator would be involved in these things. But
what's the connection? That's really
I never quite fully understood how that was done, but it led to a federal grand jury probe in Los Angeles. And that probe was, of course, very different than arbitration. Why? Well, having once been a prosecutor and a trial judge, it's amazing how people have more precise memories when there is a penalty of perjury for lying. And of course, you know, with a federal grand jury or with interviews with federal investigators, lying to them is in fact its own crime. Mm-hmm. And so people started talking, and witnesses that had given us a totally different version of events in the first arbitration suddenly seemed to have different knowledge. And as that progressed, SCA brought the fourth arbitration. And we have one of these savings, electricity savings mechanisms in our office. So it takes power. We don't need any more heat in Dallas in the summertime. So the fourth arbitration was brought by SCA, and they obtained information from a variety of sources to indicate that Armstrong had in fact been involved in doping. And then as the arbitration progressed, he went on Oprah. And in his Oprah interview, he effectively did a mea culpa. For those who are not Catholic, it's basically, you know, I've sinned, I'm confessing. And that then was used in the arbitration as part of the evidence against him. Needless to say, his lawyers in the fourth arbitration contested our jurisdiction and asserted that we had no continuing jurisdiction, despite the fact that they brought 3 arbitrations to the same tribunal previously. And that was somewhat unpersuasive, as one could imagine. And it was okay for him to bring arbitration demands, but not for his opponent. Rather a curious position, but nevertheless the one taken. And so, you know, we eventually disposed of that with an appropriate ruling saying, no, we're still empowered to hear this case. And the case progressed. We actually heard testimony again. And the fourth decision was a 2-to-1 decision. The parties had each appointed party arbitrators, so I was the true neutral in the matter. And the SCA arbitrator joined with me to find that there had been, in fact, a serious misleading of the tribunal, and that we had been presented with, shall we say, extraordinarily inaccurate testimony, and that many of the witnesses that had been presented to us either did not, in fact, have actual knowledge or had misled the tribunal. And we required the return of all of the monies that had been obtained through the first arbitration. Some would say that's an issue of sanctions. We were a little more elegant, and some would say creative in the way we wrote our award. Texas does not have a duty of good faith and fair dealing. However, we all do have contractual duties that prevent frustration. And so that, if you read the award closely, is the basis for our decision in ordering the reimbursement. And it had an interesting aspect, because after we issued our award, and there was a vigorous dissent by Senator Lyon, we thought the matter had pretty much been resolved and that the money would be returned. So unbeknownst to us, there was a motion to confirm, and the award was put into the case and became part of the evidence in the court proceeding. Well, out of the blue, we started, members of the tribunal started getting telephone calls from the news media. Mm-hmm. And one very enterprising reporter with the Wall Street Journal called me, and she had covered another case I had been involved in. And I got this call saying, "Hey, Judge Faulkner, I'd love to talk to you. I think she's calling about the other case. And she wants to talk to me about Armstrong." I said, "I can't discuss that. It's confidential." And she said, "No, your award is in the Wall Street Journal." I went, "What?" And, we had not been informed that the confirmation hearing was proceeding, or that the award was no longer confidential. Mm-hmm. And so that was the first knowledge we had that the parties were, fighting this issue. Eventually it was resolved, but it points out that we were dealing with some of the cutting edge issues in arbitration, the continuing authority of a tribunal, dealing with doping and scientific evidence. Some of the evidence that was presented to us was actually in German. We had witnesses that appeared in the Armstrong arbitration from all across the world via video links. Mm-hmm. And so long, pre-COVID-19, we were using the rather dysfunctional equivalence of Zoom of that time period to be able to hear witnesses. And we also had the concern that the first hearing, the news media was vitally interested in it. So we had to take steps to restrict access to the building, to protect Mr. Armstrong's medical records for reasons that I think are already in the public record. But we took very strong steps to ensure the security of the evidence and the confidentiality of the transcripts. Eventually, someone surfaced what purport to be the transcripts of our hearings. And the internet is the internet. Nothing ever dies or goes away, whether it's accurate or inaccurate. And so we had to do a lot of things that have since come up in conjunction with COVID. And we also have had to address some of the issues in sports, such as, what about bias by investigators, or bias by potentially involved parties? And that leads me to the recent Swiss Supreme Court case in Sung Yang versus the Agency Mondiale Antidopage, AMA, and it's another WADA case, World Anti-Doping Association case. And that also was an issue in the Armstrong case, because in our fourth award, by that time, USADA, the U.S. Anti-Doping Association, had begun prosecuting Mr. Armstrong. The federal judge in the case in Austin was not very complimentary towards USADA. And if you read our award very carefully, you will see we excluded any reliance on USADA or its investigations. I can't speak for the other arbitrators, but at least in my mind, when people associated with an investigating entity state in advance the conclusion they are going to reach, having been a trial judge, I have a serious problem with that. And we specifically disavowed any reliance or use of the USADA report, and I can confirm we made zero use of it. Specifically because of the issues as to whether or not it was independent and impartial. And so those issues again have arisen in the Sun Yang case. And there it became even more interesting because you had an arbitrator who made comments on social media. Well, how many of us are going to, withstand great scrutiny of social media? And what does that do in the sports world? The arbitrator in the Yang case apparently made some very hostile anti-Chinese comments pertaining to animals because the arbitrator was an animal rights activist. But how many arbitrators really expect everything in their social media feeds to be examined? And the Swiss Supreme Court very carefully began analyzing a duty of curiosity. And so nowadays, parties are obviously tempted to obtain as much information as possible before naming an arbitrator or arbitrators, but they also would love to have, a few arrows in the quiver in case the award should become unfortunate from their standpoint. And at what point will there be a trotting out of those issues that may or may not have been discoverable before? And sports arbitration is raising issues relating not only to social media, but think about this aspect of it. What happens when an arbitral process is unfair? And the sports world had seen another version of that in the Ezekiel Edwards case involving the NFL and the NFL Players Association. And Judge Mazant, who is here in Texas in the Eastern District, wrote a very careful and thoughtful analysis of his articulation of the really seriously unfair NFL arbitral process for player discipline. And in that case, the federal court conclusions and findings of fact were that Edwards and the Players Association were misled about the existence of evidence. The arbitrator, who was supposed to determine whether or not the executive director of the NFL's decision was correct, was appointed by the executive director of the NFL. How do you do that?
I know there's a similar situation with the Deflategate that was similar, where it was entirely very skewed and very questionable.
Well,
you know what?
Go ahead. Judge Mazant was pretty scathing in his comments, and he granted the injunction, or a temporary restraining order, barring enforcement of the suspension. And the more one reads of those decisions, there goes my lights again. Yeah, here we go. Thank you, building, sooner management, for taking away our power. So Judge Mazant was very thoughtful in his analysis, and it raises an issue of, should entities like the NFL Players Association really be using arbitration, or should they have greater input and take the appointment of the arbitrators away from the management side? None of us would tolerate a biased arbitrator knowingly, and yet we have seen in sports arbitrations, the Swiss case, the Ezekiel Edwards case, both of which call into serious question the independence and impartiality of the arbitral tribunal. And so we're seeing in sports arbitration a number of hot button issues that are contemporary and problematic. And what gets to be even more fun, since the Sun Yang case involved Chinese, is what happens if an arbitrator's social media account may make statements or raise questions about, for example, the notorious espionage of the Chinese government and all of the cyber warnings that the American and Australian governments and UK governments have given about that. Is reading such posts from the Federal Bureau of Investigation. I got another one this morning because, as you and I discussed, I do have some activity in the cyber field. And those warn about Chinese hacking attempts, amongst other things. If an arbitrator likes a post by the FBI on social media of any type, is that now a basis or even a duty to inquire or investigate?
Right.
Folks don't think that in the social media context, these are all contemporary issues Do arbitrators even use social media? I eliminated almost all of mine years ago, except for LinkedIn. We all do something there. And, this has become an issue for trial judges too. I'm married to a district judge, and I know that for a fact, trial judges have had issues relating to potential sanction by judicial commissions and questions by counsel about a judge's friend arrangements on Facebook with opposing counsel.
Yeah. Those all really interesting and important. And even, as we think about students have to be really careful with their social media. I know that's something I often have to talk to students about, is really being careful with what they're doing on social media. Can be dangerous sometimes. Back to one other question that we were talking about that I do think is really important, and there's been a lot of conversations about it, and it came up in the Armstrong case, is really often, I think there's a misperception, there's a misbelief that arbitration is always going to be private, always going to be confidential, which is false. Because I think that's a perfect example when it's made public record because the award was entered then as a judgment under the Federal Arbitration Act, it now becomes public record. And moreover, in terms of confidentiality, it's not really confidential. It's only confidential to the extent that the parties agree in their contract to confidentiality. So maybe speaking to that, because that must have been a bit of a shock when the Armstrong opinion suddenly was in the New York Times. That strikes me as a really significant issue, right? Because there it was,
so.
and that becomes new. So how does one deal with that, I suppose? How does an arbitrator navigate those waters? I guess as soon as you find out that it's public record, then of course you're free to talk. I mean, could you even be, normally you have immunity, you shouldn't be called into court, but I suppose it's possible.
Well, first of all, it begins before the award is even issued. Sometimes now you have to think, as we did, about what happens if this leaks. And the prospect of an award being filed either as a part of a motion to vacate or as, to be confirmed, is evident. It's always present. And federal courts have a presumption of the openness of courts and court records. And more than a few parties have been shocked to find that things they thought were secret and confidential are laid right on out in the arbitration awards in the federal court. Chief Judge Barbara Lynn here has actually redacted portions of arbitral awards, but only small portions. And at least one of the parties was less than pleased to find that what it thought was secret and confidential was not. But you raise something that students ought to also be aware of, which is some parties use arbitration's confidentiality as a way to mislead other parties or potential parties. And in a different context, in computer hardware and software cases, I routinely appeared as counsel against an entity that insisted it never lost. And we beat them, obtained a substantial award, which they did not pay on time. So I filed a motion to confirm. Of course, that then motivated, an overnight, very, very large check and a demand that we dismiss the case. So having known that they always claim they never lost, I filed a motion to dismiss on the basis of full payment, attached an order reciting same and a copy of the check redacting their bank account numbers. The judge signed it, so you can go find it in Pacer. So much for their claims that they never lost. And unfortunately, confidentiality and secrecy has become a problem in other areas because, remember, we don't have any rules of evidence in arbitration. So all sorts of things come in and may become part of an arbitral record that would never see the light of day in a court. And quite often you will see arbitral tribunals, even those of us who've been trial judges, say, I'll take it for what it's worth. Right. Because as arbitrators, we can get in trouble if we exclude evidence. But we can't, we'll never get in trouble for accepting evidence, no matter how potentially useless it may be. And so the tendency is to let everything in. Well, what happens if it leaks? What happens if arbitration is being used to suppress either dangerous products or, we all know, sex harassment cases were routinely shoved into arbitration. And that gets into a problem that exists in sports arbitrations and other places of the repeat player effect. And Professor Colvin has done really good research on that. And that's a huge problem because it goes to the same issues that arose in the Sun Yang case of arbitrator selection.
Mm-hmm.
You and I are repeat players in this field. I once trained many of the international arbitrators in North America for the Chartered Institute of Arbitrators. So I know arbitrators all around the world. You probably do too. But if we're opposed by a counsel or team of counsel who don't have that knowledge, we may or may not have an advantage in selecting the arbitrators. That particularly comes up in specific areas where the asymmetries of information can in fact seriously influence the outcome. And there's another issue that comes up as well, which is parties that mislead arbitrators, just as what happened in the Armstrong arbitration, but this happens in the international arbitral arena as well. Those of us in the United States or in the United Kingdom are used to reasonably honest courts and legal systems. But what happens when you go to some of the legal systems in other parts of the world? Is it trustworthy? Not so much. What happens if you have a party like certain governments that flat don't follow any rules? They will put in questionable evidence. There will be evidence that one of my professors at Oxford quipped, blew in with the blowing sands of the desert winds. And we all know very well that the national intelligence agencies or organs of that government obtain the evidence. Is it accurate? Is it inaccurate? Was it created for purposes of the arbitration? What happens with social media accounts by arbitrators that may be put as private? Well,
Right.
you and I both work in the cyber field, and so is it really private? What happens if it's hacked? And what happens to the evidence in an arbitration if that gets hacked? If you have,
these are all really great, really good questions, and most definitely, good stuff to continue the conversation. I'm just really thankful that you took time with us, and really good questions. And thank you for the insights about the Armstrong case. That was really, really interesting stuff. So, Richard, thank you. I really just want to thank you again.
Oh, thank you. I enjoyed doing it. I, hope that we will have more people entering this field. It's fun. It is exciting. It is never boring. And who knows, you too could end up with a case that ends up in the New York Times or the Wall Street Journal or the Times of London, or even the
Amen.
Straits Times of Singapore. Thank you very much.